Good morning, everyone. It is 9 o'clock and we are going to get started. Can I get some feedback to see if my audio is working? Try it again. My speaker was down. I guess I don't hear anybody. That means maybe I don't have audio. Okay, I'm unmuted. You sure nobody can hear me? Oh boy. Tamara, could you get Carol going for back? Back. I'm not getting any audio at the moment.
Fine.
Yeah. If you have, wait a minute, if you have a camera and video, if not, then Daisy in front might have them. Huh. Test microphone. Testing microphone. Okay, testing speaker. I have speak. Got it.
Hi, good morning.
Oh, good. Hi, Ziyu Yan. Thank
Yeah.
you for the reinforcement that my microphone's working.
Hmm.
I thought maybe John would pipe in too, but he's been pretty quiet.
Yeah, I have heard you. It just wasn't doing something.
Okay. And when we got the list from the Contra Costa County Library, how do you pronounce your name? Zui
And the Hui Yan.
Say Hui.
Yes.
Okay. And we'll need to get your email address. I don't want to put it on the video though, so that we could communicate.
Yeah. My email address is Z as in zebra, E as in Edward, H as in Harvard, U as in Union, I as in Indian, L as in Larry, I as in Indian, at yahoo.com.
At Yahoo. Okay.
Yeah, Yahoo. Yeah.
Great, thank you. Well, let me introduce myself. I'm Rex Crandell. I'm a CPA and attorney in Walnut Creek, and we've been teaching this class, I don't know, 7 years or so. For the Contra Costa County Law Library, and particularly to help out the judges. The intention was to help people who were pro per representing themselves without an attorney and needed help with court accounting. And it's gone well. We give it every other month. It's been well received. We've gotten lots of thanks from the judges for help cleaning up their paperwork. And we plan on continuing to do that. So my assistant, Tamara Brown, is here, but she's not on camera yet. She will be. We've divided up the course into more of, I'm a CPA and an attorney, and since it's CPA stuff, I'm doing the one with the number forms. And Tamara's a legal document assistant in American Canyon, and she's going to be doing more of the legal preparation of the court papers, the report to go to the judge that includes the accounting,
So
and other request stuff. You have a question?
yeah, I have a question. I filed quite a few accounting report, but I never get approved. I would like to know if you can help me clean out the problem in my accounting to submit to the court in order to get approved.
Okay, so let me see if I understand this right. You turned in an accounting to the court, and the probate examiners rejected it.
Not reject, it's always going on. So I filed quite a few, then I withdraw previous one. So right now I filing the second amended accounting. So I don't know how.
Well, that's the purpose of the class. What you have is the those are called examiner notes. And they grade your paperwork like a high school, college teacher. And they point out all the mistakes that they
Yeah.
want you fixed before the hearing.
That's right.
And if there's formatting problems, you can go to the probate exam. What court are you in?
Contra Costa County.
Okay, so on the second floor of the probate examiner's office during office hours, I don't know what it is, 9 to 10, I don't know. And you can bring your papers and say, could you look at this for formatting? Not the numbers. I don't want you to approve it. Just could you look at the formatting to see that I'm in the proper format? Do you want to go?
Yeah.
Ready to get started.
Okay. So that's a suggestion, but we will have many, many more suggestions as
Yeah.
time goes on. Now I'd like to introduce my assistant, Tamara Brown. Da 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 da.
Hello all, I'm wearing a mask because Rex is sick and I don't wish to get that. So if you can't hear me or I'm not talking loud enough, just let me know, okay?
Okay.
We are gonna go through quite a few things today. Starting off with the inventory and appraisal. Please understand that when we're talking this, the forms are already pre-populated for the class. They are populated as if it's a law firm completing the forms. So I'm gonna go through how you would complete them yourself. This is the very start of how you would do an accounting for a conservatorship, guardianship, or a probate. So this is how I begin. I do them for several different law firms all the way down south, Southern California, and do all of them, quite a few of them up north. I am located up north, but I still have about 5 or 6 law firms down south, so I do their accountings also. So it really, all I'm trying to say with that is it really doesn't matter where you are located or where your accounting needs to be turned in, whether it's down south or way up north, the accountings are still the same. So I'm gonna go through quite a few things with you. If I need to stop, if you have questions, if I'm going too fast, if I skip something that's important to you, please let me know. Otherwise, we're just gonna keep going through the form. So when an accounting is due for a decedent estate, it's due right before you're ready for final distribution. If you're doing a conservatorship, it's due the first year after appointment, whether that appointment is temporary first or whether it's permanent. And then after the first year, it's due every 2 years after. For a guardian, same thing. It's due the first year that the appointment, and then it's due every 2 years after that. So just keep that in mind. Sorry, I have the screen a little far back, can't see it. And so an accounting will always start. Oh, let me back up. The first accounting you turn in will always start with the inventory and appraisal. A second, third, fourth, and so on and so forth will begin the day after your last accounting, so you'll pull numbers forward. But we're going to go through this as if it's the first accounting and you need to turn in your first accounting. So before, on a decedent's estate or a conservatorship estate, usually a conservatorship, when it's granted, you have, I believe it's 90 days to turn in an inventory and appraisal. So in some cases, you'll have already done the inventory and appraisal, but you really need it. You need to make sure it's accurate before you can even start an accounting. If your inventory and appraisal is wrong in any way, you cannot do an accounting until you correct it, because all of your numbers are going to be off, and you'll see as we go along. So the form for an inventory and appraisal is either going to be called a DE, which means decedent's estate 160, or it's a GC 040. GC is guardianship or conservatorship, and 040 is the form number. Again, they will be blank, but for just showing and education purposes, this is already completed. So instead of the name of the attorney, it will be your name, your address, city, state, zip, your telephone number. Fax is optional. Most people don't have fax machines anymore. Your email address. The reason for the email address is typically if the examiners have questions for you, or if some counties, more so down south, they will email the tentative rulings to you when they are ready. And they only email, they don't call, they don't. So a lot of times they just like to have your email address on file. Where it says attorney for, you would put your name, comma, and in the case, it would be pro per, and that's PRO space PER. You're telling the courts that you are you are not represented by an attorney. You will put in the county. This is Orange or down south. In your case, you would put in Contra Costa. You would complete the address for Contra Costa. And the court, it's Wakefield Taylor for probate. On the estate, now the estate of, this name is one of three different names. It's either going to be the decedent's name, and you would mark this box. It will be the conservatee's name, and you would mark this box, or it's going to be the minor's name. You would also include, if on your petition, the person is known by another name, whether it's a former married name, whether it's a different variation, because I know in many families, many nationalities, sometimes you use mom, dad's name all in there and things of that nature. So if that was the case, typically this name should be whatever on the death certificate or whatever the legal name of the conservatee or minor is. And then if they do go by other names, you would put AKA and all of those other names after. But you would have started that on your petition, and you would just move it forward. On this side, you will put your case number. For Contra Costa, they start with a P or MSP. I usually don't include the MS. I would just include the P, and then I would put the case number. Now, on an inventory and appraisal, there are several different things you can mark, and I'm gonna go real quickly through what they are, just so you understand what you're marking when you're marking the box. Partial. Sometimes I'll do a partial when, especially if it's a conservatee or minor, when I know I have real properties. Sorry, I don't know what alarm's going off.
Sorry.
I'm sorry. So I would do a partial, say for instance, so there's many things. A probate referee values some assets and you value some other assets. When I would do a partial I would do, like, say for instance, if I know there's real property, there's a home, and I don't know yet what type of cash assets I have or any other assets. I would do a partial because of the fact that real property has to be valued by a probate referee, whereas cash and cash equivalent assets are valued by the person who is the administrator, the conservator, or the guardian. So the probate referee takes a little bit longer to do as value. So if I really wanted to do a quick, I would do a partial. I would just put the real property, and then I would come back and do another that's called a final, and then I would include cash. So in some cases, you may have two inventory and appraisals you need to use to start your accounting. A corrected one would be, say, for instance, you filed an incorrect, or not purposely, it was just an accident, and it was an incorrect number, incorrect starting balance, an incorrect date of start. You would do a corrected, and then you would do your accounting off the corrected. Most of the time you're going to be doing a final, which means I'm going to include everything in one shot. And so our example shows a final. A reappraisal is usually only used for decedent's estates. Maybe not, but and or say for instance, you need to sell the real property. If it's a decedent who passed away in 2012 and we're now in 2024, the probate referee is only giving a value as of 2012. And so you would need a reappraisal if you wanted to sell it now, because we're in 2014. So the value of the property would be completely different. And the courts, especially if you're under limited jurisdiction, will only allow you to sell a property under court supervision, and the inventory and appraisal has to be within 1 year. These other two, which is supplements and the property tax certificates, I don't use property tax certificates often. In fact, I think I've done one in thousands, so it's not used very often. And different people use the supplemental for different ways. The supplemental kind of could be a second partial. I don't use it often either. I really only use the partial, the final, or a reappraisal. And corrected if I'm looking at somebody's accounting for them and I notice that it is incorrect. Okay, so now we have the case number, and this date is very, very important. That's going to be the date of your start of your accounting. It's going to be many other things. This date, and I'm going to give you just quick, this date can be a date for different things. It's either the date of death, if this box decedent's marked. It's the date of appointment or the order signed by the judge if it's a conservatorship, and same with a minor. So what does that mean? Be careful with your date right here, because it will be watched. Your accounting will be rejected if it's the wrong date, if it's too late, if it's too early, if it's too whatever. So let's go into where does this date come from? Go ahead, hun.
I have a question. For the date, I'm not sure this one says at the date I was appointed as a conservator, right?
Honey, I'm gonna go through right now where the date comes from and how to find it. If you could just give me a second, okay?
And then we have a dispute according to the date, because they said my letter was issued 1 month later. For example, I was appointed at June 30th. The order was issued on that day. Then later on, I obtained my letter on July 30th.
Yes,
So,
honey, I'm gonna go through that. If you
Okay.
just wait 1 second for me, you'll be able to hear the answer in that, okay?
okay, thank
And
you.
if you still have your question after I've done the explanation, please stop me, okay? So where does this date come from, and what date is the real date you use? Okay, so again, decedent's estate, this is the date of death only. So it only applies to the decedent's estate. For a conservatee or a minor guardianship. So keep in mind that some people file temporary. So you want a temporary emergency appointment or temporary emergency appointment for a guardianship. What is the date would you use here for appointment? You got to be very careful. It's the date of an order. The date the order was signed by a judge is the date you're responsible going forward. It's not the date of letters. Date of letters can be much later based on many facts. The facts could be that you had to get a bond. The facts could be that you had to do other things, and the facts could be you just never went to the courthouse and got certified letters. It is not based on when you got your letters. It is based on what date the judge signed the order. The order will be the GC, I think it's 320, don't quote me, but or it's the DE 140. No, yeah, maybe I'm not thinking, I don't know my numbers, but it's something close. It's your order. The date you signed, the judge signed the orders. What if it's for a temporary and you got temporary first? It's when the judge signed the temporary orders. It's not when the judge you got your letters for a permanent. So be careful on this date. This date again is the date the judge signed your order. Is that clear, hun? Does that help?
Yeah, it helps, but the court seems like they get messed up too. So and they could not, the first time I did the letter was issued. Then they said, you should do the where you appointed. Then I put I changed the date to the time I was appointed. Then I submitted the first accounting. Then the investigator says, that they have a tentative ruling says, why you put the inventory appraisal start the accounting date in June 30. Maybe file the accounting start date is different from appraisal, inventory appraisal. So then they said that your letter was issued on July 30th. So the accounting should start on July 30th.
Okay, but you don't listen to them. You listen to the examiners, because the examiners absolutely 100%, and I know all three examiners in Contra Costa, they have been around for years and they're very, very, very good. They've taken this class. I'm telling you, this date right here needs to be the date the order was signed by the judge appointing you as the conservator.
Yeah, and also the accounting should start on that date too, right? The
No.
first accounting.
The accounting starts this day right here.
Yeah,
We'll go into it. We'll go into that, honey. We'll explain more as we go along.
So it means the accounting will start at the time the appointment was signed.
The order was signed.
Order was assigned. Okay,
Yes.
okay. So I got it clear. So that's what I'm doing now. I have to change the, first time I started the different date. Right now I have to change your second date.
Yes, you will see how this date is important and how it transfers to the accounting. As we go along, you will see that. Okay, now we're gonna go down to the total appraisal by representative. That's called the attachment 1. That is cash only. Attachment 1 is valued by you, the personal representative, the administrator, the guardian, or the conservator. And it is only cash and cash only. I can't tell you enough, just cash. And we will go into what does an attachment 1 look like. I'm going to switch screens. It is a different attachment. It is the DE 161, or if you're doing guardianship conservatorship, it's a 041. You will put the name of the estate. Again, this is the name that appears right here. You will put the case number, which is the case number you've put right here. You will put that it is an attachment 1. You will put how many pages it is, and then you will start listing what is your cash equivalent items. Now, keep in mind, again, it's only cash. So you will see where the other assets go. You may not have this many cash assets. These are only examples for you to follow. You may only have one. There's times I've done there are times that I have done a inventory and appraisal and there was no cash. So I put cash assets 0 right here. So again, you won't have this many likely, or you could, but we're gonna go through what they are. So cash found at a residence. I myself do not believe I put, in fact, I'm positive, I never put the conservatee's address. I don't suggest it. This is a public document that anybody could obtain on their own. Telling people that there's cash at the conservatee's residence is never a great idea. I would say cash found at the conservatee's residence and leave it at that. So in this case, these are examples for a conservatee. I became a conservator of the person and the estate, and I located at their home, they had cash in their wallet of $250. The second example would be balance in a checking account. You have to be very careful with this. You only list the last 4 digits of the account number. The courts are okay with that. They understand. You never would give the full account number because, again, this is a public document. If the conservatee is still using this bank account by you giving the full account number, you're exposing them to scams and a whole lot of other things. Courts will give you a very stern little subtle hint that it is your responsibility to obtain privacy for the conservatee or a minor, and you have violated it. One of the first things that indicates is you've given a full account number. So please be careful. And again, only use 4 or 5 digits, last digits of the account number when you explain. Now, I also do not put the address because many accounts like Bank of America, Wells Fargo, and many other branches, they're all over the place. It doesn't matter what branch the conservatee does their accounting at. I myself typically would say balance in Wells Fargo checking account number 1234 and leave it at that. Now, what's really important and what screws up a whole lot of accountings that I fix on a regular basis is that you don't understand what balance you're supposed to use. So now I have many people that, okay, I'm going to use this example and I'm going to slide up. The appointment was on March 8th of 2012. Now, when the person goes to do the accounting, they look and they see a bank statement that ends March 31st of 2012, and they go, oh, okay, there's the balance, and they put that number in there. That is wrong, wrong, wrong. It is your job and your responsibility to figure out what was the exact balance on this day, and you must indicate on your inventory and appraisal the exact balance on that day. You have to turn in bank statements, so the examiners are looking to see that you are accurate in stating what the starting balance is. Now your accounting will never balance if this number's wrong. So a lot of times when people come to me and say, hey, Tim, I can't get my accounting to balance, the first thing I'm looking at, give me your inventory and appraisal. Second thing I'm looking at is what is your starting balance. So this is a second example. I myself would say balance in Wells Fargo savings account number 2345 or something different. And then again, this balance is as of date of appointment, which is this date right here. Okay, moving on, I found, I went through the mail at the conservatee's house and I found that they had, or maybe it was just sitting on a counter. I found they had a CD. This was the deposit number. This was who issued it. This was the name. I don't think I go into that much detail. I usually will just say, CD from blah, 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 and I will state the amount. This is rare. I rarely see these. So now that I'm going to go down and we have uncashed checks from a pension. Now, it used to be, and the reason why the example says this, most people would say, well, why are they even getting checks? Because most pensions now will only direct deposit. You rarely see, in fact, I haven't in a very, very, very long time, uncashed checks. But it could happen. So if I go in, open the mail, I see that the pension check is a check, it hasn't been deposited, I will indicate that on my inventory and appraisal, because remember, I'm going to deposit it after I got appointed, so I'm going to account for it in my accounting, and so they're going to want to see it. Here's another where Social Security, nowadays, Social Security is automatically deposited into a checking or savings or wherever it goes. So they don't issue checks, and there would be no uncashed checks for Social Security, but back in our sample, they had uncashed checks, so I would indicate it here. Lastly, there also could be dividends. So if the conservatee or the minor has annuities, and there are several different ways that annuities will pay out dividends, or what is also technically called interest, but it's really not. So what they used to do is every month issue out, or sometimes being the age of the person, instead of reinvesting the dividends, which majority of people do, they will issue a separate check for dividends, and in that case, you had a dividend check. Then I will go down, and as soon as I have all my cash assets together on this sheet, I will come down. I do not say total cash assets. I myself type in total attachment 1 assets, and then I do not put my total over here either. I put it in the middle. And this number down here is the total of all of your cash assets. You will take this total and you will go back to your inventory and appraisal, and you will put that on line 1. Now, the second thing you will do after you've done that is you will go to attachment 2. This is only appraised by the probate referee, no one else. You cannot give value on anything here. It is attachment 2. It is the same form, and we're going to switch over to that form. It is, but it's non-cash assets. So in the same form, DE 161 or the GCO 41, name of the estate and the case number, it becomes attachment 2, so totally different attachment. You have page 1 of 1, and we're going to show you examples of what are assets that would be included on attachment 2. Again, you do not give value for any of these assets. Most of these assets will come off of your, like, so if you're filing a probate and you're doing the petition, which is the DE 111, you've indicated what, you know, the value of the estate is. I myself, when I'm looking at these, preparing inventory and appraisals, also, I usually go to the petition. I see what did you originally state were your assets, and then I'm trying to make sure you kind of have indicated them all on the inventory and appraisal. So in this case, our conservatee has real property in the city and county, and I do this. I myself have the ability to run deeds, so I do put the legal description for the probate referee. And truly, that's what this is. And a lot of times I will also put the condition of the property. For instance, a lot of times the conservatee was moved out and moved to a care home. Maybe let's just say a year before the conservatorship was obtained, and squatters got in, or somebody came in and robbed the place and completely destroyed, and the house is in shambles and stuff like that. If that is the case, I do put that information in for the probate referee, because it does change the value greatly, especially for a decedent's estate, and they want to sell the property, and they have to get 90% of the value of this probate referee. So say, for instance, the probate referee values it at $1 million. The house is in shambles on the inside, and you know you're not going to get more than 500 or 600. You would never get an offer, because it would never come, you'd never be able to sell, because it doesn't come in at 90% of the value, and then you have other problems. You have to have a probate referee revalue the property, and so on and so forth. So make sure you've indicated things like that. Now, I'm not talking it needs a paint job. No, I'm not talking the front yard has to be mowed and landscaped and just clean. No, I'm talking real serious items that decrease the value of the property. I'll give you another example. So I had a conservatee moved into a home. Her house was vacant. It did get robbed, or people came in, robbed a few things. They took the hot water heater. Now, hot water heaters are fairly expensive. You can't, the house, the roof, I don't know why, but they put holes in the ceilings, all in the bedrooms. I don't know what they did, but I had to indicate all of that, because they were selling the house as is. They didn't have money to put into it, so the value of the property was greatly decreased. So I made sure I indicated that for the probate referee. Now, the second example is a vacation home. This conservatee had a vacation home in Palm Springs. Again, I list the legal description and the assessor's parcel number and everything about the home that I do know. If you do not know this information, just give as much as possible. Like, you know it's real property, you know what city it's located in, you can figure out what county it's located in, state of California. You may not know the legal description, but you could state it's commonly known as, what is the street address? You can look up an APN number online by going to the tax collector, the county recorder, or the tax collector. Otherwise, if you really don't want to go through that, you don't put the APN there. You will notice there are no values. It is because you cannot value the property, only the probate referee can. So this is left blank for them. Next instance will be household furniture and furnishings. And we'll put the, I don't put address of where this furniture is located. Sometimes I do put household furniture and furnishings, but most of the time I do not. Household furniture and furnishings, even though you may have a full house full of furniture, the value of it is so insignificant, it's not even worth mentioning. Now, that's not what I'm saying. Like, say for instance, if you have antique furniture or specific items of extreme, value. Maybe you had this designer sofa and love seat, or maybe you had a designer coffee table, or, something that that does have value. I would list that as a separate item, so that a probate referee can understand, because most of the time for a whole house of furniture and fixtures, you get 500, maybe $1,000, maybe. Most of the time, not. I mean, it's fairly limited. So I mean, it's really, really not even necessary, but depends. Most of the time in a decedent's estate, uh, they just haul off the furniture and it goes to Goodwill, or it goes to, a small little garage sale or something like that. But in this case, this is a conservatee's home, so you're not getting rid of any furniture. And so just listing it is fine. Another example would be shares in a mutual fund or annuities. Keep in mind, if your conservatee or decedent has a big portfolio somewhere with Safeguard and doesn't just have one set of shares, you must list all shares separately. And you're like, most of the time, like, I'll get people who will turn it in and they'll say 100,000 shares at Charles Schwab. No, sir, that does not work at all. You will need to get a Charles Schwab statement. You will need to see, is it 100 shares in AT&T? And in addition to that, a lot of times I help the probate referee by giving the code of the stock, because you will see on any mutual fund annuities statement like that, there will be a, I think it's 3 or 4 digit abbreviation for the stock or whatever code. And in that case, I will provide it to the probate referee. But again, you cannot lump shares. You must provide each individual share, and I'm sorry, each individual name of the share and how many shares there are. So another example would be savings bonds. You don't see these often, but I've seen them more lately. But in this case, there was 7/100 US savings bonds when they were issued, because that makes a difference. And in this case, there was a 2-carat wedding ring. A lot of people, or sometimes that I have been asked in the past, what difference does it make? Why would you put a wedding ring or a diamond ring or a blah, blah, blah? And then I will go on to tell you, if I was a conservator and I went in and saw the conservatee had a ring, I probably couldn't tell you if it was 1 carat, 2 carat, or 3 or 4. Maybe if it was 4, that would seem big to me, but I'm just not great at knowing those things. So you say, okay, well, how would I know? You have to just use your best estimate. Now, keep in mind, why is even that important? So let's go with a conservatee's case. So you have a conservatee, you are the conservator, and maybe the conservatee's family lives in other states. They just cannot care for her, so they've, hired you or asked you as a friend or a family member. And some of those children of the conservatee might not, I wouldn't say be difficult, they're more difficult than others. And or say, for instance, I've had one where we indicated on the inventory and appraisal that it was a 2-carat diamond wedding ring, and then one of the children filed an objection with the court that said, what are you talking about? I know my dad bought her a 5-carat ring. Why are you only listing the 2-carat? Did you take it? All kinds of other things just went rampant. It's really important that you list things like that, because believe it or not, some of the children know it and they're looking or waiting for an inheritance of possibly that ring. So not a whole lot of other jewelry. I don't list, like, for instance, a lot of older people have tons and tons and tons of jewelry. I don't list that. I just list the bigger, I guess, items. You could have many other things. You could have nothing. You could only have a house, so your inventory on attachment 2 would only be 1 item. You could, you could have 2 pages or 3 pages if you have more. Make sure, especially like here, you would indicate like an animal, maybe a horse. maybe horses, maybe cattle, you would put that here. There are many different things that you could put on here because again, it's anything that is non-cash item. Oh, one thing I do also see that I don't see on here, that you must put is vehicles. I list, if they have a vehicle, I list that vehicle. And there's a lot of time, like say when you're doing your accounting, say you forget or you don't list a vehicle, but then you do your accounting and a lot of your accounting includes gas. The first thing the probate examiners are going to say, well, hold on a minute, how do you have gas but you don't have a vehicle? That doesn't make sense. You know, so if that kind of thing happens, you'll go, oh, I forgot to put on the inventory and appraisal of the car. You're going to have to go back and get another inventory and appraisal done because you didn't put the car. You have to have that all squared away before you can turn in an accounting. So it's going to be extended on your approval time. When I list a car, I list the year, the make, the model, and the mileage. And a lot of times I'll put the condition. So I had recently was it a conservatorship account? No, decedent's estate, but listed a 2015 Mercedes. I think it got valued at, because it was maybe a little under 100,000 in mileage, it got valued at 16,000. Right, it came back and the administrator goes, hold on, are you kidding me? It's in a driveway, it doesn't have an oil pan, the engine is frozen. It really isn't worth almost $2 because it's so expensive to fix and she doesn't have the funds to fix it. And I'm like, why didn't you say that to me before we even did the inventory and appraisal? So then we had to go back because the car might be worth, in the condition it was in, maybe 6,000, not 16,000, as if it was a running, you know, nice car and that I could sell it right then and there. So, you know, there's certain little things like that. Just be careful and make sure, you know, you're accurate in what you say you have and you give the details. And remember that you're talking a probate referee who's, you know, in another office. He doesn't know the condition of the stuff. You're right there. You see it, you know it, you've dealt with it, etc. So make sure you include all those things. Coin collection, that's another big one I've had recently. Coin collection, sometimes that's rather difficult. Like if you go into a conservative's homes, and it's a gentleman, most of the time it's the gentleman, and there's a water jug full of pennies. Do you think I'm gonna sit there and count those pennies? Absolutely not. I'm an estate, you know, I see this huge water jug full of pennies and blah blah blah. If there are certain ones that are put, like some people put certain gold, silver coins that have certain years or certain emblems or whatever on a sheet of paper or something like that, I'll indicate those separately. Artwork, kind of the same thing. And then sometimes I could go into or see a conservatives and they'll tell me, how do I know what if that painting is worth, you know, if it's a painting that's worth something or not? And I'm clueless on that too. I probably just wouldn't even state it. And if one of the children said, hold on a minute, they have antique paintings, then I would go back and do a corrected. So, you know, you're doing your best. You're not expected to be, you know, an investigator. You're just doing your best to indicate whatever you can. At the bottom, I usually put total attachment to assets and leave it blank as in here, because you will not value this. Now, we're going to go back to the rest of the form. Again, it's left blank. You will only see my number from attachment 1. Continuing down the form, I'm indicating that attachment 1 and 2, we just went over, are all of the estate. There's nothing more. Now, if you're doing a partial though, you must mark the box portion. because it's not all. Down here, number 4, you have to mark one of these 2 boxes. What this first one would be, say you only had cash assets. The conservatee did not have any real property, did not have a vehicle, did not have anything else that I would put on an attachment 2. In that case, I would mark this box. No probate referee was required. Otherwise, I would mark this box and say, yes, a probate referee was given to me by order of the court. Again, the word order is very important. By order of the court, that's where they will indicate your probate referee. And you have to indicate the date the judge signed that order. Now, property tax certificate, this is only completed if there's real property. Again, in our case, attachment 2, sorry, wrong attachment. I have real property in Orange County and I have real property in Palm Springs. So on this inventory and appraisal, I will be indicating 1A, there was no property, so I don't have to worry about it. Or B, I have indicated or sent documents to the county assessor that I am now the conservator and the conservatee is no longer in charge or responsible for their real property. You must complete that for a decedent's affidavit of death of real property owner, or affidavit of death of joint tenant, or affidavit of death of trustee, one of those 3. If it's a conservatee and they're still living there, it's the conservatorship. You'll indicate that you are now the conservator of the conservatee, and so on and so forth. If it's a minor and a minor was to, and minors can't inherit property, but say they do, has to be a guardianship first, which is why this is up here, and it'll be, again, you indicate that the property will then be transferred from an inheritance to a minor via a deed that says that it is given to the guardian of the minor and until they're 18, and then the minor needs to go change the deed to his or her own name. So you must mark one of these 2 boxes. Now, if you don't and forget, the probate referees will probate examiners, I'm sorry, will come back and say that you haven't indicated this and you need to. Okay, so at this point, we haven't sent this off to the probate referee yet, so you will not date, sign it, do anything with it yet. You can print in your name or type in your name here, but again, you do not date or sign this till it comes back to you, and I'll go into that further in just a moment. Statement about a bond, you're going to mark one of these 3 boxes. Your bond was either waived, meaning you did not have to obtain a bond before you got your letters, or a bond was filed, in what amount. So say, for instance, the court didn't know really what your assets were and they issued minimum bond. Minimum bond's $20,000. So the court just says, okay, go get a $20,000 bond. Now you're doing your inventory and appraisal. You have cash of $57,000. I can guarantee you that the court's going to come back and go, okay, now I'm increasing your bond to match because what they want to do is the bond needs to match the cash assets in case they disappear. So a bond for $20,000 would be insufficient at this point because it does not cover all of your cash. Now, if the bond's $20,000 and this is only $17,000, then you would mark sufficient because your bond does cover your cash. The third would be putting receipts in a blocked account. Now, a minor, again, cannot inherit any type of money. So if they are to inherit, it has to go into a blocked account somewhere. Blocked account means it cannot be touched without court order or until the minor turns 18 years old. They go into the bank, they show ID, I'm 18 now, and the account is changed from a blocked account to a regular account, and they have access to all their funds. So if the monies are in a blocked account, you would mark this box, put the amount of money that's in the account, and indicate like Wells Fargo, Bank of America, credit union, whatever, and you would mark that box. Again, this will usually be the name of the attorney, but since you don't have one, this will be your name. You won't sign or do anything with it right now. And we're going to move on to page 2. So we're almost done with the inventory and appraisal. So again, you would put this name is the same name that you will see right here. The conservatee and the case number. This is to be filled out by the probate referee when they are done appraising the property. They will state what their statutory compensation is. Statutory compensation right now is 1% of the value of the property that they appraised. So let's say your attachment 2 that they appraise is $100,000. They will be paid 1%. But they will also have expenses that include mileage and whatever other photocopies or pulling deeds or whatever. They would have other expenses, and they will put a total here. This is for the court. They will then date and put their name, and they will sign it. Now, again, you're going to take this and you're going to mail this off to the probate referee, and you're going to, I always include a letter that says, hi, you were appointed as my probate referee. There's a copy of the order showing your name as the probate referee. Please do me a favor and value the attachment 2 assets. And I include the inventory and appraisal and then the order, and then send it off to him or her. Once they have completed attachment 2 and completed this and dated and sign it, they will mail it back to you. At that point, you will review it. They will also indicate a number up here for attachment 2, and they will total it. You will again review it, and then if you feel it is accurate and ready to turn into the court, you will date it, you will sign it in 2 places because you have to date and sign here also, and you will turn in the entire document to the court. Now, understand that they will also give you an invoice at that time. It's up to you to pay that invoice and get it handled. And depending on if it's a decedent's estate or a conservatee, usually sometimes with decedent's estate, if you don't pay that bill within a certain amount of time, the probate referee will file a creditor claim, and then there's no distribution. And the courts also see you're really not doing your job because you're not paying the decedent's bill, things of that nature. So I say when you get the bill, please make sure you pay the probate referee and get that accomplished. So then you will file this document and you are ready to start your accounting. Again, it's going to be very important, which Rex will take the accounting portion of the class, that the numbers to start your accounting, this is going to be the date. This is going to be your beginning cash assets. Whatever number the probate referee has indicated here is going to be your beginning non-cash assets. And this total right here better be the total of your beginning assets. So now that I have gone through the inventory and appraisal, which is the first part of doing an accounting, is there any questions on just the inventory and appraisal?
So,
Go ahead, hon.
yeah, I have a question about the conservative cash or assets, which do I need to include the cash in trustee accounts? So,
Okay, now let me keep that difference. So when a conservator has a trust
yeah,
and you have property and items listed in the trust, you do not ever put it on the inventory and appraisal. The trust part has to be as a separate case, go under court supervision, just like the conservatee. So you would indicate that you have a trust, you have the real property in trust, you have cash and checkings and savings in trust. And so the court will go, okay, now you're gonna give me and do an accounting later on a trust, and so I'm watching that the trust assets are, do not disappear. But on your inventory and appraisal, you're for a conservatorship account, you would never include on here assets that are titled in the name of a trust. You don't put them on here. They're too, you're talking, this conservatee technically doesn't own those assets, or it's not a conservatee asset. Is it a trust asset? It's a totally separate ball of wax. So again, if all of your cash assets, all your checking, your savings, and your annuities, or which that's attachment 2, sorry, we're on cash. All of your cash assets are in the name of the trust. You will have one line item that says cash assets 0 and your appraised value is 0. And you don't account for them in your accounting for the conservatee. It's a totally, you must file separately with the court for the trust, for the trust itself. It's required. Again, non-cash assets, same thing. If the house, sorry, it's non-cash, if this house is titled in the name of a trust, I would not include it here. Vacation rental in the name of the trust would not include it here. So nothing in the name of the trust is included on this inventory and appraisal, and you do not account for it in your accounting.
so I have a question. I'm not sure if, I was appointed as a guardian enlightenment trustee from the court, the workers' compensation court. They also appointed me as a trustee to receive the benefit from the settlement of the workers' compensation. Do you think that would consider as a trustee account that I received the money in a account called the guardian enlightenment trustee?
Well, then it's a trust asset. It's going to be deposited into a trust, so it would not be included on this account.
Oh, okay. So I have another question. The foreign currency, in conservatives box, like a safe box has a Chinese money. Do you think that would consider as cash, or would consider as a asset that needs to be appraised?
It's an asset on item number 2. Foreign currency is not typically valued by you. It's valued by a probate referee.
Oh, so that one cannot consider as cash. It has to be appraised by the
Correct.
referee. Okay, so and another question is, at the date of appointment, the inventory appraisal would start on that day. Is that day inclusive or exclusive? For example, do I need to, if my date is June 30th, so do I need to put the balance of June 30th bank amount there? Or should I put the day before June 30th?
No, you can't put the day before. You are responsible for every asset on the date the judge signs the order. So that is the date you must include, and not before, not after. It has to be the date the judge signed the order and you became responsible for the asset.
Yeah, but there are something, you know, something like I have some purchase, for example, I have some purchase the day before I was appointed, but that purchase was not paid until the day after appointed. I
Then
appointed.
you're still very, unfortunately, you're still responsible for it. You're gonna give the balance on the day you were appointed. And if an item that was purchased prior to you
Yeah.
comes out of the bank in the time period that, or the day after you were appointed, you're responsible for that item and you must include it on your accounting.
So it means that item was paid on the day I was appointed. Do I need to, for example, on the day the balance was originally was 2,500.
You wouldn't include
the,
any items that go through on the day of your appointment.
yeah.
That's just your starting balance. So the very next day, if there was an item, you would include that. But stuff that happened on the day you were appointed, you're not responsible for. You only report items that hit the day after you were appointed.
So this is a little bit tricky because on June 30th, the bank paid for some purchase happened before the appointment date. For example, they paid $200, which is the purchase incurred the day before, a few days before the appointment. But on that day, the balance says 2,500. Then the bank has something says on the bank statement, it says they paid $200. So in that for the purchase happened before, then I think then I put deducted the 200 on that day. Then the inventory would be 2,300.
No, again, your balance on this day is not the balance in the morning before transactions went through. It's balance in the evening when everything's done, and then you're responsible for things that happen the next day. So your balance here would be the ending balance on that day. And then that's what you would start with. And then on your accounting, your deductible items or expenses would be the day after. You would only include the items on the day after, not the date you were appointed.
Oh, okay. The day after. So I think the bank statement, they don't put the balance of the every day. They put like a few days they have a balance run for a few days. For the date I was appointed, there was no bank balance there. They would have a balance a few days after or a few days before. So I have to,
No, honey, it's your responsibility to go to the bank and ask them what was the balance on this specific day.
Oh.
And you can get something from them that will tell you what was the balance on that specific day.
Okay. So and also at the end of the accounting.
Okay, we're gonna get into, you'll probably get your answers to your question possibly as he goes through the counting and you get to the ending accounting.
Okay.
So we'll save them for that, okay?
Okay.
Because you might get your answer there.
Yeah.
Okay, I'm gonna let him take over now. I will be returning at the very end because I'm gonna go over with you how to prepare the petition to get this accounting approved. And so that's a part I will be going over, but I'm going to turn it over to Rex and I'll see you in about an hour. Thank you.
Thank you very much.
I'm gonna run the post office.
Okay. Do you have the key? You have the key. Key.
Oh, I can do yours. Yeah. I was thinking.
Okay. So, are we having fun yet? I sure hope so. If not, we'll try to liven it up a little bit. So what Tamara focused on, just recap, was the inventory and appraisal. First step of what you need to have for your court accounting, and it goes in 9 months from the date of your appointment. And that's at one point in time. Now we're going to talk about something different. We're going to talk about at the end of 1 year from appointment, you have to turn in accounting to the court for approval. And that is from the beginning of appointment all the way to the end of the day before the next year. So if it was your accounting stopped at March 31, started at March 31, you would go all the way to what, March 30th. So you'd make sure you had 365 days, and all the transactions that happened during that time period will be indicated on your accounting. Every transaction, whether it's by bank or by cash or some other method. So let me move ahead to my forms. And it looks pretty close here. Oh, there we go. Okay, so in court accounting, there's one form that's pivotal, and the probate examiners will look at this particular form first. It's like bicycle spokes, all your other schedules come out. This is the centerpiece, the axle. And it is called a GC 400 sum, meaning summary. And they could have picked better numbers for their forms, but all of them are GC 400 letters. But this particular form, you'll see in the, oh, by the way, page numbers. I will, in the lower left, there is page numbers in your handout, and I am on page 21. That'll help you keep up with the different pages as I move through them. Okay, so the GC 400 sum, always required. Even if you do your accounting on Excel or other type of software, this form needs to be filled out and included with your accounting, along with your original bank statements. They always require that. Now, you go through the top of the form. It's repetitive from before, but if you happen to have a trust, you'll put trust. Guardianship here. Sometimes we'll have power of attorney forms that need to have court accounting. And so, as I mentioned, first 90 days after that, you file your inventory appraisal. After 365 days, you file this form, and we're talking about the first account. I mean, if it's going 12 years, you're going to have 12 of them. And the date range over a period of time, March 8th, year 1, to March 7th, year 2. And your case number, seems like it should have a P on there, but as I have a little bit of a cold, excuse me. On the lower left, it says, this form is adopted for mandatory use. So it's required. Some of the others will show are for optional use if you want to use them. Judicial Council, we have the California Supreme Court. Below the Supreme Court is the Judicial Council. They're like the board of directors for the court system. Below that, we have Administrative Office of the Court. That is the administrative arm for Judicial Council. And then we have all the superior and appellate courts below that. So if there's a required form or any form that's needed for court, Judicial Council makes the decision that that is what you're going to be using. So Tamara went over in great detail lines 1A, 1B. We've already talked about the cash. We've already got assets, non-cash assets with the probate referee appraisal. And then we total it out on line 1C. Now we're going to go through all the other forms, all the money coming in, all the money going out. But I wanted to mention a couple other things. If you want to provide court accounting for a business, like a side business, you can do that. There's no license required. It's basically a bookkeeping service. You don't need approval from the court. You don't need to be a CPA or anything like that. Generally, in addition to the inventory and appraisal, the court accounting, there's a cover sheet that goes on top of it. That would be a report and then a petition for approval of the accounting. And that is done on normal court paper, the 28 lines on the left. Tamara will show you how to do that. So who needs to get court approval? Anyone who's a guardian, conservator, executor would have to get their accounting approved. It's optional for trusts. Revocable trust, when someone dies, it becomes an irrevocable trust. We prepare them. However, a trust is never required to do an accounting unless a beneficiary demands it. Then it must be done for the beneficiary. Or if there's a dispute as to the trust and it goes to court and they demand an accounting, this format must be used. Other form of background stuff, formatting. Your pages must be in portrait view. We've seen people try to do spreadsheets in landscape view. They got kicked out and said, out, can't process it.
So how about the expenses? Do I need to do all those form as a portrait? Because some of the expenses is too wide to for
It's
the.
not too wide. We'll show you. It goes down the page. It does not go wide.
Oh,
It does not.
yeah, because mine was too wide if you print out the,
Listen to what
portrait.
I'm saying.
Yeah,
Every page going in the court must be portrait view.
yeah.
I don't care.
Oh, all the pages,
All pages must be portrait. If you
oh,
put in landscape,
yeah.
the probate referee will not process it. For some
Oh.
reason, their glasses don't work landscape. They can't do it. I don't know. It's just a court rule.
Oh,
It's not like you get to debate it. That's the law.
because sometimes you put like a spreadsheet, you put
Yeah,
the
forget it. That's
landscaping.
what I'm trying to tell you.
Yeah,
You put a spreadsheet in, you put it horizontal,
then
you're
it'll
not
work.
getting that page approved.
Oh, okay.
Excuse me
Okay.
while I choke.
Bless you.
No problem. So we're doing all portrait. Let's see, step by step. Let's see, two. I'm looking for my notes here. When you turn in your accounting, at least 2 weeks before your hearing, you will need to go to the court website and look up under your judge, under the day of your hearing, and pull down what's called tentative rulings. It's also called examiner notes. This is very important. You got a hearing coming up on the 15th. You go on this first, you look and see what the examiner notes say for your court for the hearing date that you're gonna have. And they may have written out a list of 10 items you gotta fix. Get rid of all the landscape pages.
Mm.
You have to do it before the hearing, or the judge is gonna say the same thing.
Oh,
So it gives you a chance to fix things before the hearing, which is nice. It's kind of like being graded your college paper. Nah, you didn't do this right. Nah, you didn't do that right. And so you read it, you see what they're saying, you fix it before the hearing. Okay, so let me move. Back on the probate referee, I'll just give you a side reference. For assets, fixed assets. There's a California Probate Referees Association that has an online booklet that has everything that the probate referees are supposed to do. How to look up values of coins. So you can use that to help you. Okay, moving right along. All righty, great. So what we're doing is summary of account, and it says standard or simplified. There are two different formats. I only teach standard accounting. Simplified, I don't discuss it at all other than define it. And that basically, if you got 5 transactions per year, you can show just the bank transactions. And it's so simple. But I still wouldn't use that format. Okay, so first account and final account. So one time and you're going to get rid of this whole project. Unless it's going to go on for many years like a guardianship, then you would not check final. Okay, so we got all the way down to inventory appraisal items. Now we're going to go through the detail of each of these lines of income, cash, money coming in. It may not be taxable, but it's money coming into the estate or trust. Each of these lines, you can look at it kind of like a link on a computer. You click on the link and there might be 4 or 5 pages back describing Schedule A. And that's how the probate examiners look at it. There's a term used in court accounting. Well, a couple of them. One, it doesn't make any sense to me, but they call it charges. This is charge of your responsibility. So you're charged with the responsibility for all this stuff that came in. And then you get credit or relieved of your liability for all the credits, which are appropriate things that went out. Unusual terms, not normal accounting, certainly not debits and credits. If you know that system, forget it. Doesn't apply here. And that's one of the problems. You know, I went to CPA school and they don't teach anything about this. And some CPAs say, oh yeah, I know how to do court accounting. You hire them and they don't. And they do it all wrong. And that causes a problem because the court doesn't want to allow you to pay twice for the same service. So if you're going to hire a service provider, you really have to know that they are not just saying they know how to do this. Okay, so we're going to go through the individual items coming in, the disbursements, and then we'll, at the end of the account period, which is March 7th, we will tally up the assets, the cash, and the non-cash, and see what we have at the end. So inventory and appraisal in the beginning, accounting report, ending inventory and appraisal. And you'll see a term on this form on page 21 that says carry value. Carry value. Well, my euphemism for that is you're carrying this burden of all these assets. You're responsible. If anything happens, it's your neck on the line. And that's the term that is used. So if you have a house that's been appraised for 950,000 and the market changes over time, doesn't touch your accounting. The whole time you're doing the accounting, it's 950,000. So you can look at the carry value as burden. Same thing with stocks. With when you're doing tax, you say, what did you pay for it? What'd you sell it for? Okay, capital gain if you sold it. With court accounting, it's what your initial inventory and appraisal says. That's your carry value, which if it had been income tax, they would call it basis. It's a similar term, but not used here. Okay, so on the list of items that we're going to be tracking, we're going to income, additional property received. Found $100,000 worth of bonds under the mattress of the conservatee. Receipts received, banks, dividends, selling a property, other charges that don't fit other categories. And then this one's really nice if there's a business. You do not have to account for all of the income and expense of a business. You just get the accountant's report that's done on normal accounting. And it says this is how much the income was. And that's the number you use. So it's really handy in that regard. Okay. Now, disbursements, we're going to go through each of these. We have a whole list, laundry list of disbursements, losses on sale of assets, other credits, loss on trade from trade or business. And then we get into the inventory and appraisal. Hey, John, you doing okay out there? Haven't heard a word from you.
Yeah.
Maybe you could unmute and say hi, but okay, go ahead. Say
Hi.
when.
Yeah.
You
I
got a
have
question?
Yeah, I have a question regarding the liabilities. I have during the time, some of the fee I paid, like the conservator's expenses, I
Yeah.
paid out of my pocket. So how can I get that effect in the accounting, the summary accounting? I was putting
I understand the question.
other charges.
I understand the question. Let me answer.
Yeah.
It depends on what the expenses were for. If the expenses were just ordinary disbursements
Yeah.
for administration, you just put them under that expense. And then you have another entry that says funds advanced by conservator.
So
They owe you.
Yeah, should I put it in the credit or put it in the charge? Like the
Okay.
advanced, like the cash advanced by the conservator, should I put
Okay,
it
look,
in the
look,
credit
look,
or put it in
okay,
the?
look, we have
Yeah.
we have disbursements,
Yeah.
and that's what you track first. Then money came in,
Yeah.
other charges, advanced funds from conservator. So it's money coming in, you track the money coming in, the money going out, you track the money coming out.
So coming in means received. Oh, for example, if I transfer my money from my account to the conservative's account, that should call the money coming in as
It is.
Yeah,
It did come in.
advanced payment. Oh, that
Huh?
should affect as advanced payment. Put it in the other charges, right?
I understand. This is how you do it.
Yeah.
It
So-
came in,
Yeah.
advanced funds from conservator. It
Yeah.
went out, payment for medical bill, went out.
Oh, so how about I did not really put the money in the account. I just paid out
You
of my
treat it
pocket.
like it was in an account. It doesn't
Yeah.
have to be in an account.
Okay,
It
so
could be in cash.
sometimes I just pay the as my cash, or I pay the from my credit card to
It
the.
doesn't matter. It doesn't
But-
matter. You paid it however the heck you paid it.
Okay.
It's money coming in. You paid it
Oh.
by credit card, I don't care. You paid it by
Oh.
your own check, I don't care.
Oh.
If money came in and then you immediately used it for an expense for appropriate purpose. Now you're owed that
Oh.
money.
Okay, so whatever I paid, I still should put the other charges. No matter is
Describe it.
Yeah.
Describe it.
Yeah, I put a
Cash
item
advance
5.
from say when. Okay, so let me continue
Okay.
because you're asking specific questions and we're not there yet.
Oh, okay. Thank
We're
you.
gonna cover specific a lot,
Oh,
of which we're gonna start now. So, the
definitely.
first thing that the probate examiners do in looking at your accounting is that they compare what came in total charges and they compare total disbursements.
Okay.
If it does not balance, don't even bother turning it in. It's not worth it. And unfortunately, I disagree with the courts. And I'm kind of rebellious, but the courts say you have to account for every penny. Every penny. And my response is pennies are not worth anything anymore. A buck's not worth anything anymore. So I do what IRS says, and I'm not suggesting you do this. It's just my objectionate way of doing things, is I round to the nearest dollar. We do that on income tax all day long. But that's my problem, not yours. They want all the pennies and heck with it. For me, I don't, I'll let them whine about it. Anyway, now we're going through a whole bunch of different forms that will all tie together, and all the numbers from all these different forms are going to end up here on this GC 400 summary, or you can call it summary of account. Okay, so on your now we're talking about the beginning of the counting period. They want to know what assets you had in the beginning of the counting period. And I said, well, wait a minute. I gave you an inventory and appraisal. I went over that in detail. So you can either refer to that or rewrite the numbers, for the cash on hand, the bank accounts. And this is the beginning of the count. And then all the non-cash, same thing. You can list, the house for 950,000. And on your first account, you ignore the second column because you just got it appraised. You have no idea what difference. What are you talking about? Estimated market. That is the market value. So in your accounting 2, 3, 4, and 5, the value of the house is going to change. So you can get on Zillow, Realtor.com, some of those other places, and just write down an estimated value. It's really good to do that with stock accounts because sometimes the beneficiaries object to your investment policies. So you can show that the whole account's going up or down. And this number is, you're just guessing or computing it. You're not held to it, but it gives disclosure to the beneficiaries and the court. So these two forms, cash, we just went on, non-cash, identical to your inventory and appraisal, except in year 2, you add a market value. Now, this form, it's a summary sheet. And like I said, I don't really agree with the way they came up with their numbers and things, but all the darn accounting forms are GC 400 sum. Come on, let's be creative. But that's what it is. And then they have an additional letter to indicate, you know, a certain income item. And then beneath that is a subletter. So, but each of these items are going to have like one or more accounting papers behind it to support that total. Total dividends, 35,000. You go back to the dividend sheet and it shows every dividend that came in that you pulled off the broker's statement. And it says here, don't file it with the court, fine. It makes sense to me because we're going to have all these pages in the back with number for each transaction. And this summarizes it from all those subschedules. And you see here it says total for Schedule A. We go back to the GC 400 sum on page 21. And it says total Schedule A. So it follows what you're going to be summarizing to the next step. This one is disbursements. So in this one, Schedule C. What is the total of all the disbursements? You go back to the GC 400 sum on page 21. And there it is. It tells you this is all the disbursements that start with Schedule C. Excuse me. Okay. Now we are getting into the fine detail of the transactions. Every transaction must be shown for the entire account. Every item on a bank statement, every item on a broker statement. So here, we went through the broker statement and we found, gee, all these dividends came in. We list each one of them when it was received. Receipts of dividends. Now, we had some savings accounts, let's say. There again, we take it off the statement, how much interest came in, listing each item. Then run the total for the interest. You total the dividends on a separate page. Then we get into receipts. So they're giving us, we're doing income first, obviously. And then the court forms give you a clue and kind of give you some guidance so it looks logical. And this particular form, GC 400 for all of them, A3 has to do with pension receipts. So if they had a pension, a 401(b) or 401k, you list each pension payment as it came in. But Social Security gets in a different place. And on the original form that we talked about, GC 400 summary, it said mandatory use. Well, that's like you must. Here, Judicial Council says approved for optional use. So if you want to use this form, Schedule A, 3, you can use it. If you have a spreadsheet on Excel, it kind of matches this format. Okay, use it. This form's not required. The format is. But I teach the government forms because it gives you context if you later branch out into Excel. Okay, so we're doing pensions. Now we have rental income. We have a rental house, Newport Beach. And each rent payment that comes in, you have to list it. You notice there's no expenses yet. Why? Because we're just focusing right now on all the income items for the entire year. And even if you're using an Excel spreadsheet, I would still use this number system. Here we're doing Social Security, veterans benefits, public benefits, A5. Now, we had a probate examiner take this class. They're all required to take our class. And she looked at this page and immediately she says, that's wrong. You can't do that. You can't report it that way. No way. What she meant, remember I said you have to enter every transaction. What the person did here is they took a quarterly statement, added it all up for the quarter, and then put the number of the total. No can do. Every dollar coming in, every dollar going out must be shown separately. Now, there's another feature in accounting, and that is you're only burdened with what you actually get into the estate or conservatorship. And that is, okay, so let's say the Social Security was supposed to be $1,000 a month. Social Security said, we're giving you $1,000 a month. And then Social Security, in the same breath, says, oh yeah, we're going to take out for Medi-Cal. And so you only get $757. You do not put the $1,000 that Social Security said they were giving. You only put in what you actually got. So in this case, you only actually got $757. That will be the number that you enter. So there's going to be other things that are going to impact income tax, but that's beyond the scope of what we're talking about here.
So I have a question. Should I put the joint account to the accounting of a conservatorship? Because I have a joint account with the conservatee, we receive the Social Security as a representative payee. So in that case, should I put that money in the conservatorship account, or because I have accounted to the Social Security?
Okay, let me answer your question.
Yeah, yearly I counted it to the Social Security.
First of all, you're not allowed to have joint accounts with a conservatee. These accounts must be the conservatee only. If you have a joint account, that means when let me finish. When you have a joint account, that means that when the conservatee dies, it's automatically your money. You cannot do that. You're mixing things that are personal with things that belong to the conservatee. So
but
get your name off the account. Your name should only be on there as conservator. You're not part owner. It is not a joint account.
So, but that joint account is we established it before the appointment of the conservatorship.
You gotta fix it. You got a problem. It's wrong.
You think that's wrong with the?
I know it's wrong.
That's what we had before. We had.
I don't care.
Okay.
It's wrong now. That's the answer.
Okay, so it means after appointment of the conservatorship, I needed to take my name off.
You need to get your name off that account right now. You have no right putting your name on a conservator's account. That's wrong. It's called commingling. It's a breach of fiduciary duty. If the court knows about it, they're going to reprimand you.
So if I already removed, I'm no longer the conservator, can I still keep that account?
Just open a new account in the conservator's name only until Social Security put it in the new one. That's all you need to do. Get your name off.
For the Social Security purpose, right?
Okay, so the next item.
But
I gotta finish this
Okay.
thing up. I can't
Okay.
answer questions every line.
Okay.
We have other receipts. Now it says other, and basically this is miscellaneous that maybe didn't fit in other forms. Okay, we got a tax refund. Okay, fine. We got a health insurance refund. Okay, fine. We got a Medicare reimbursement. Okay, it's all miscellaneous stuff for money coming in. And if we had, say, when putting money into the conservatorship out of our own pocket, guess what? Came in advancement from conservator for the benefit of the ward, dollar amount for, let's say, medical. You know, this is the receipt part, whether you paid it in cash or check or credit card. So miscellaneous kind of stuff. Gain on sales. We start with, like always, a list of assets that we have carry value from your inventory and appraisal. And it will also have an asset number from your very first inventory and appraisal. You give every asset an asset number, line number. Never change it. Never adjust the numbers. If you sell asset number 7, leave number 7 blank from then on, because the probate examiners cross-reference those numbers to future transactions. So let's say this house is asset number 10. I would put a 10 out here. It was appraised originally $230,000. We're selling it for $250,000. Gross sales price before expenses, and they want you to report the gain. It's basically a gross gain. It's not accurate because there are a lot of expenses, but we'll show where the expenses go in a few moments. Now, asset number 10 is gone. So in your future inventory sheet showing your fixed assets, number 10 will just be a blank line. Or number 10, house sold in 2023, whatever it is. But there's no dollar amount from then on. And by the way, you cannot use court accounting directly to do income tax. You sold the house. This estate, either the individual as a conservatee will have an income tax. If it's a decedent's estate, you'll have a fiduciary income tax return due on an IRS form 1041, California form FTB 541 by the end of the calendar year. Well, by April 15th. Okay, so we got the house sale. Now, okay, so all those other forms we looked at were either A or B, which means they were all gains or assets coming in. Now, what page am I on so I don't lose my place? 29. Okay, so I'm going to go back up to page 21 because we just finished all the income. And what's page 21? Your favorite form, GC 400 summary. Since we finished all the income, you fill out the rest of the lines 2, 3, 4, 5, and 6, because we're done with the income at this point. Now we're going to switch gears and watch the money go out of the estate or conservatorship. And we have another set of forms for those. Okay, for that, we're going to go to page 30, 30. Disbursements. Now, see, you'll see the number here. We're on the C series. Disbursements. In this case, the ward was in a convalescent hospital, skilled nursing facility, and you were writing checks. So you put the check numbers. And list all the items that were paid.
Mm.
And we total out the page for the Schedule C2. Then we'll go to disbursements. You might have a lot of them. You might have rental expenses, different things. With this form, C5, it's more like general and administrative expenses, things that are needed to operate the conservatorship or the probate estate. So we're listing bond. See, David Lowry was the conservator. He put up the money first. Now we're reimbursing him because he paid the bond. Okay, the attorney had advanced costs. You can pay an attorney to reimburse them for advanced costs, but you cannot pay the conservator, the executor, or the attorney anything as income until the court approves it. So these are just reimbursements. Okay, here's our probate referee coming up with our inventory and appraisal. And then we had a bond premium to protect the assets of the estate from potential malfeasance of the executor conservator. So we total out this expense page. Now we have disbursements, just any old living expenses, cable, food, things of that nature, garbage, whatever, if they're living in a house, including gifts, you know, to the conservatee for birthday and things like that, within reason. If anything looks like it might be a benefit to the conservator or the executor, always describe it and tell the probate examiners and the judge, how does it relate? Why is it needed for the conservatee? They will ask if you don't put it in. So you have reimbursement for incidental grooming expenses. Okay, fine. What was it? Well, razor blades, hairspray, and a comb. Well, that doesn't sound like, well, but the person needs it. It directs them. It's not for the conservator. Disbursements medical. Just list them as they were paid. And this would only be, if there's a copay, it's only the out-of-pocket cost. It's not the total thing.
Mm.
And if there's no out-of-pocket cost, there's nothing to write here. Okay, we sold the house, as you recall, earlier. That was on the income pages. We're on the expense pages. And we have this money going out to We Close Escrow Inc. So there's an escrow fee, termite, real estate broker commission, all the expenses you pull off the seller's final closing statement. Only these types of expenses that are called non-recurring closing costs. If they're recurring closing costs, like say property tax or insurance, you only deduct those when you actually pay for those benefits. But here, these are the non-recurring closing costs we write off. There was a loan that was paid off. Now that's gone. In this case, there was household furnishings. They hired a consignment company. They sold all the stuff. We put the income before, and we're just showing the 500 we paid commission for the consignment company to sell the asset. Now we're back at the rental. And if you're used to doing income tax, this is totally bizarre. because all the rental expenses are listed chronologically. And if you're doing a tax return, you don't list it chronologically, you list it by totals. How much was the gardener for the year? How much was the property tax for the year? Insurance. How much was mortgage interest? But in this report, the way they want it, they want to show the money going out. So these loan payments are in fact a combination of principal and interest. But for right now, the only thing that's important is the money went out. The accountant will deal with the interest sometime later. And you cannot switch these to categories. I mean, unless you do the chronological in addition to a separate page for categories. You're always able to do that once you meet your obligation for chronological income and disbursements. Other miscellaneous disbursements, income tax, preparer, and then income tax due to the IRS. Now, we sold the old jalopy that was on the books at $31.25 value when you took over as conservator. Only sold for $3,000. Went down in value. So what? We just showed the loss, and then this asset number might be asset 15. We keep that number open and never use it again on the inventory and appraisal. Okay, so this is the switch point where we've posted all the expenses. And we're on page 38, so I don't lose my place. Now, since we've got all the expenses listed, we go back to that famous form GC 400 sum on page 21. And we list all the disbursements with all the Schedule C and subschedules, all the losses on sale. And so we have now accounted for all the money going out. Then what happens, you'll notice that this looks very similar. Beginning inventory and appraisal. Now we're down at the end of the account period. Gee, you want to know that again? Yes. So we go to the schedules that show that, page 38 or 39. Okay, so assets on hand at the end of the account period. Mine, get all the cash balance on that date, March 7th. Just list them. Run a total of the cash. Now, on the non-cash, you list all the items from your inventory and appraisal that you still have on hand. And this is, time has gone by since you were appointed, and you must have the carry value for all those items that match up for that asset number. And then you can give an estimate to value. You're not held accountable for it, but do a good faith estimate what it might be worth. It might go on Zillow for a house, for example. So it shows what might be liquidated for. Then we have the ending assets on hand. We go back to GC 400 sum, page 21. And we list the cash at the end. We list the non-cash at the end of the account, and we total. These are assets. So what we have now is cash and fixed assets subtotal. All the income coming in, subtotal, total charges, responsibility of you. Then we have all the money going out. And then we have what's left over. And the total charges must equal total disbursements. And your credits, I should say, and your charges must match. If they don't, you're not done. Some mistakes people make: if you've got property out of state, it does not go into the account. Tamara had mentioned if you have assets in a trust that's not part of a probate or guardianship, doesn't enter here. Only things you're responsible for. And if you have been doing spreadsheets, there's no law that says you cannot do a spreadsheet for the GC 400 sum as part of your account. But you must take those numbers and fill out this form, the GC 400 sum. Required. And then bank statements go to the court for all the intervening bank and broker statements, so they can cross-check your numbers. So this discussion that we've just had on income and disbursements is the bulk of the court accounting. Are there any questions?
Yeah, I have a question about the refund. There are two types of refund. One is a refund for the purchase out of conservative account. Another refund is out of my advanced payment. For example, if I charge conservative expenses on my credit card, then they come with a refund.
Okay, what you're having, let me clarify.
Yeah.
If you pay too much insurance and they give you money back, that's a refund.
Yeah.
Okay,
So,
now, when you pay money and you get it back, that's not a refund. That's called a reimbursement to conservator.
Yeah.
Reimbursement is not a refund.
oh, so I needed to deduct the reimbursement money from the refund. For example, if the
No,
refund,
no, you never net numbers. Okay, so give me an example of what you're getting reimbursed for.
okay. For example, I purchased the clothes.
Close, stop there,
I
close,
okay.
close, stop there. You paid for it. Now let me answer. Okay, so what happened was disbursements. Okay,
I returned.
you keep interrupting me. Let me finish your answer, please. I can't talk when you're talking. Now, disbursements, you bought clothes. So you go to disbursements, and when you get to disbursements, you write clothes, purchase for ward. We had the one on living expenses here. Okay. That date, conservator bought clothes for ward. And the money went out, $500. Okay. Now we show the money going out. Now what are we going to do? Because they owe you. Okay. So that's a disbursement. And now we need to get you reimbursed. And I would put that one under, well, you have to show the money coming in because you contributed money to the conservatorship. So receipts, miscellaneous. Money received from conservator, $500. So money came in. Now we got to pay you back. We have the close already. We're showing that you brought money in. Now we have to pay you back.
Yeah.
Then we go to a disbursement, and it's a miscellaneous. Okay, miscellaneous disbursement. reimbursing conservator for funds advanced to buy clothes, $500.
Mm.
Question?
So then I paid first, then later, partial of it get a refund because, for example, I bought 2 clothes, I returned one, then
Okay, hold on. You gotta change wording from the word refund to reimbursement. Now, if you bought clothes for, you have to take each transaction separate. You paid $500. Okay, now you're telling me you're changing the facts. So the example is going to be different now. Okay, you paid, and we just already talked about the $500.
Yeah.
Now you're changing the facts, and you're saying you brought it back to Macy's, and they gave you $100 back, right?
That's right.
Let me answer that. They gave you money, so that's money coming in. We go to the miscellaneous income item again. Miscellaneous receipts. Received $100 refund from Macy's for clothes returned to store. That's a receipt. Okay.
So this receipt is a for my account, not for conservative account. You know what I mean? The one.
No, I do know what you mean, and you're mistaking it.
Yeah.
When you put up $500 to buy clothes, that's it. The clothes hit the conservatee, you're owed $500.
Yeah.
Fine, it's done. But you went and got money back on the conservatee's owned clothes. They are theirs, not yours. So you bring the conservatee's clothes down, get a refund from what Macy's, that's income from Macy for the conservatee.
Yeah. But they refunded to my account, not to conservatee.
I don't care what account, show it.
Oh, that's
Look at this. Look.
Okay.
Where does it say that these were deposited in somebody's account? A tax refund. Does it say what account it went into? No. We got health insurance reimbursement. Does it say what account it went into? No.
No.
So what do you care? It's really the conservatee's money that needs to show as it's owned by the conservatee.
No matter where who bought the clothes, the refund went to whose account, they all would consider as a refund for the conservatee, not for,
Right.
because
the money, the clothes were owned by the conservatee. The clothes were taken back. And the clothes were changed for $100 refund. That $100 is an asset of the conservatee.
Oh, okay. Refund would be.
It's not your money.
We paid
It's
the
not
500.
your money.
Okay, we paid the 500, then get a refund for 100. Then that the conservative only paid the 400 eventually because they returned the one item. So
no, the 100 went back to the conservatee, but you advanced 500. It didn't go to you, so you're still owed 500.
I still owe the 500, but the money returned to my account. For example, my credit card, I paid the 500.
Okay, you can only report a transaction one way.
Yeah,
what you're doing is you're taking a transaction. I'm telling you how to report it. And then you're going back through and trying to report it a different way. You're going to drive yourself crazy with that logic. This is for the conservator. You don't count. Okay?
Yeah.
The money, extra 100, came back to the conservatee because it was their clothes that generated the 100. It has nothing to do with you.
Oh.
You don't exist.
Okay, then they still owed
they still owe you $500.
Oh, they still owe me, but so the $500 would not change to 400. It's still keep the same thing.
Don't change it.
Oh,
Okay, I'm done answering questions because Tamara's eagerly waiting. So
Okay.
I'm gonna turn the program over to Tamara for the final account report. She'll be right here.
okay, thank you.
Oop,
What can I, okay. Tamara will be right here for you.
Hi,
Hi.
welcome back.
Thank you very much.
you.
So the last thing we're gonna go through now is you've completed your accounting and you need to turn it into the court. And you need to prepare a document that tells the court exactly what you're turning in, why, and what do you want the court to do with it. So that is called a petition. And how you're going to start the petition, because it's not on a regular form, it is on a pleading paper. So you would have to type on the internet pleading paper so that you can get the pleading paper, which is numbered along the side. You will start off by putting your name, your address, your phone number, your email address. Attorney 4, you're going to put your name as pro per. You're going to come down a few lines, put Superior Court of California, county of, and you will indicate what county you're filing this in. It is, sorry, I'm gonna move the screen a tiny bit without it falling. In this case, we have conservatorship of the person and the estate. If you're doing an accounting and it is only a conservatorship of the if it's only of the conservatorship of the estate, you would only indicate that. You would not be doing an accounting if it was a conservatorship of only the person, because an accounting only has to do with money, which is called the estate, right? The person is how you care for a conservatee. This could say, so if I have a decedent, I would put in Ray, R-E, and then the decedent's name. So, you know, this can change based on, are you a guardian for a minor? You're a guardian of the state, then you would put the minor's name and put minor here. Okay, then you would list case number, and this case number would be the same as what you've indicated on your inventory and appraisal. I space these out. I don't put them on top of each other, but that's completely up to you. I will indicate it's the first account or the second account or the third account or how many other accounts you're at. So it's the, in this case, we're going to say it's the first account and report of the conservator. It would be, if it was a decedent's estate, first account and report of administrator. If it was a minor account, it'd be first account and report of the guardian, right? And a petition for the settlement, meaning you approve the accounting. You're also going to ask for approval because in this case, we sold a depreciating property. And for you to get paid if that's what you're requesting, and for an attorney if you had hired an attorney. Now, again, this is not going to be your caption. If you don't have an attorney, you would just end it here. This would not be your caption if you're not asking for allowance or fees. You would end it here. So this is going to be, what are you asking for? What are you doing here with the accounting? You must put date of hearing and you would leave that blank. You would put the time, you would leave that blank, because that's all going to be filled in by the court when you submit your accounting to the court and get a court date. They will fill this in. Department, you could put that if you know the department. that's completely up to you, or leave it blank. The filing clerks will add that in. I myself do not put judicial officer here, because of the fact that you have so many judges that you know, it changes based on the day. I just don't put judicial officer there, so that's up to you. So how are we gonna start this? You are considered the petitioner regardless of what your title is. If you are conservator, fine, you're still a petitioner. If you are an administrator, executor of an estate, fine, you're still a petitioner. If you're a guardian, fine, you're still a petitioner. So in this case, you are the petitioner. You will put your name. And here I do this all the time. So what this means is you're telling the reader that from here after, I'm only going to say I'm conservator. I'm not going to keep repeating myself and my full name as conservator. I'm just going to refer to myself as the conservator. So they can look back, and anytime you use the word conservator, they know you're talking about David Lowry, right? So as conservator of the state of Jeannie Lowry, who is the conservatee, I present, or David presents, for settlement and allowance, his verified first account, current, and report of the state and all of his acts as the conservator only during this time period. And as the petitioner, he respectfully states these facts. So again, every document you submit to the court, make sure you have the understanding that your document must stand alone. What does that mean? I should be able to read from the document you turn in and understand everything about it. It's not here, I was appointed over here, but go ahead and go look it up because you already know the answer. No, that's not how we do this. So what are you going to do? You're going to give the judge, who is the reader and the probate examiners, an idea what are they talking about, and so they know too, by reading this, they can go back and look at your accounting and see things and understand you properly know, and you're completing it properly. So the first thing you'll do is say appointment. So I, the petitioner, was appointed conservator of the person and the estate. Again, you would state what your title is. Of the conservatee, she's also known as Jeannie Gray. And I was appointed on March 8th. That's the date the judge signed the order. And letters were issued on March 14th. You have two different dates here. This is my order. This is my letters. You will start your accounting, your inventory, and everything on the order date, not the letter date. So at all times since my appointment, I have been acting as the conservator. Next line item, my inventory and appraisal, we went through that. My inventory and appraisal of the state that was returned and filed with the court, you will indicate the date you filed it, shows a total value of the estate of 1,342,258.59. First thing the probate examiners are going to do, what do you think they're going to do? First thing they're going to go is, I want to see your inventory and appraisal. I want to see it says that. Great, you're good. Let's go. I want to see the beginning of your accounting. What is your beginning assets on your accounting? Sorry, I'm trying to locate that. What do your beginning assets say? Wow, great, match. We're on a roll. There's your checklist, right? So you've given them all they need to look at. They don't have to look through their files and go on this wild goose chase. You gave it to them, right? Now they're like, great, check, check. We're all good. Period of account. my period of account goes from March 8th to March 7th, because again, remember I told you for a conservatorship and a guardianship, it must be 1 year. The first one's due 1 year. So you'll follow that track. Again, they'll look and say, okay, March 8th, same date they have up here stating they were appointed March 8th. Look at the inventory and appraisal. It says March 8th. Everything says March 8th, another check mark. Now, credits and charges. This comes from the accounting that you just completed. So you state in here that all the credits and charges are set forth on the schedule. So I completed the schedule. They're also on the summary of the account, and all of that's going to be attached. We're going to keep going. So authorized investments, very important. You must keep the conservatees' cash in an interest-bearing account. If the conservatees' account, okay, so you take over, you go to the bank, you state you're now the conservator, you're responsible for the conservatees' money, you make sure it's in an interest-bearing account. Let me tell you one example and or why. It is because that's not your money and it is to draw interest. I can tell you what will also happen, or what has happened. I've only seen it one time in the past, but one time is good enough for me. A conservator did not put the money of the conservatee in an interest-bearing account. Several years went on, she managed her money, never spent anything, everything was great. The conservatee passed away. It was time for distribution to her family. One of the children filed a lawsuit against the conservator and said that she lost, based on the amount of money that was in the conservatee's account, she lost approximately, let's just go with $1,000, because the conservatee did not put it in an interest-bearing account. So basically she lost money for the heirs of the conservatee. She won that case. The conservator was then responsible for paying that beneficiary heir the $1,000 because they did not have the money in an interest-bearing account. If you're okay with paying somebody that are going through that type of litigation, then fine, don't put in an interest-bearing account. And I can tell you, if you indicate here that it was not in an interest-bearing account, likely the courts can possibly remove you. If you put on here it's in an interest-bearing account and it's not, very easy for them to see by going to your accounting. If they're not showing interest every month, guess what? They know you're not in an interest-bearing account. So basically you've lied under penalty of perjury, and there are other things that can happen. So, you know, you must invest the conservatives funds, the minors funds. Well, the minors funds have to be in a blocked account. So I believe typically they accrue interest. And a probate supposed to do the same thing. So make sure, even if you don't know, like go into the bank, make sure you know these things, because that's your responsibility. Okay, statement of liabilities. So in this petition, we have liabilities and liens on the assets. Typically, that would be if somebody filed a lien or not. You know, you have to tailor this based on your accounting and what does it says. There are no taxes due or unpaid, and there's no judgments there, and the state is not liable for any, let's say, nobody's filing lawsuits against them. Nobody has something against them at that point. So now we're on, what did we do? So these should be in every single account petition for approval of the accounting regardless. Now we're getting into a couple items that are on my sample that I'm just giving you that won't necessarily mean you will include in yours. i.e. the first one, a sale of an automobile. If you didn't sell an automobile, well, surely you're not going to put in a petition, well, sale of automobile, and then go, I didn't sell one. No, you just wouldn't indicate that, right? So you would skip this, maybe you would skip, this, but be careful when I say that, because I've said it in past accountings. And then if somebody turned in an accounting into the court who had taken the class and it got rejected, and they came back to me and they're like, I don't understand. You said if I didn't need it or it didn't belong to my particular situation to remove it. And I'm like, there's maybe one or two things on there, not 5. You didn't include whether the account was in a interest bearing. You didn't include whether there was liabilities. Further on, you didn't include about a bond. Like, you can't take out anything but, again, things that don't pertain to your situation. And if you didn't sell an automobile, you would not indicate in there. But maybe you sold maybe they lived on the farm, they had tractor equipment, or maybe you did sell jewelry, or maybe you sold other things, so you would put that in there. So let's go on through our example. So in our accounting example we showed you, there was a sale of an automobile. So you state, I sold that automobile. It was on the inventory and appraisal. Again, attachment 2, because it's a non-cash asset. It was item number 7. And unfortunately, I sold it for a loss. I indicated that loss on a Schedule D, which in the accounting, you put losses on a Schedule D. And I want to confirm as the conservator that the court approves me selling this vehicle at the loss. And that was all you would put. Here's another sample of furniture. I assume that they sold the vacation home, because likely if somebody is in a conservatorship, they're not traveling to vacation homes. Because if they're able kind of to travel to vacation homes, likely they don't need a conservatorship. But anyway, in this case, they sold furniture that was in the home. It was on the inventory and appraisal. It's attachment 2. They state why they did it, because the home was rented and the family had their own furniture, so they didn't need it, and the conservatee already had furniture. And so storing furniture was going to cost more than the furniture was worth. So there's an investigator's report that determined the level of care, so on and so forth. So it goes on and on. They used there wasn't enough for an auction, so the property was sold by a dealer, a consignment shop. You can say it was sold by you, and you keep going on and on about what happened. And the conservatee, you didn't ask them because they wouldn't know what you meant when you said that. And you can state that or don't state it at all. That's totally up to you. You're just providing like all of the reasons why you sold the property. Okay, so there was a sale of real property. You sold the vacation home. Again, they wouldn't be going back. There was a gain on the vacation home. That's on the Schedule B as in boy. And in order, the order for this court. So in this case, most of the time I will, or not most of the time, every time, for a if it's a conservatorship or a minor, anytime you try and sell real property or really any item of the conservatees, you must ask the court, especially real property. For a decedent's estate, you really only have to get court confirmation of a sale if you're given limited authority. And you will know that by what is your letter state? Do you have full authority or do you have limited authority? If you have limited authority, it has to be a court confirmation sale. So that's why it's indicated here. Additional bond. I'm sorry. So at the time we sold the vacation home, so again, we're talking about bond in cash. And so again, I use the example that I started with at the very beginning. When you applied for the conservatorship, there wasn't much cash. So the court ordered a minimum $20,000 bond. All of a sudden now you've sold a vacation home. The vacation home, you made a profit for the conservatee. That's, let's just say $800,000. Well, now you have to tell the court, I don't have enough money, and you can either go and increase the bond yourself, or say you need to increase the bond, or tell the court, I realize that my bond is not sufficient for all the cash I have, and let the court tell you you need to get a new bond. Number 11, this is a very important, and must be on every single one. It's very important that you state whether you have hired an agent who is a family member. Reason being, I use the same example, and every time I teach the class, that the conservatee used to or has her lawn mowed twice a week. I said twice a month, every other week. And the gardener decides, I'm the conservator, to tell me he's going to be gone for 2 months on vacation. So what does that mean? I've got to find somebody who still mows the lawn, unless it's during a rainy period, and maybe I can go once a month, or, but I still have to find somebody, right? So and again, I use this example. So my son is home from, because it's summertime, my son is home from college and on winter break, or on break, and he's at home. I know he knows how to mow lawns. I know he knows how to weed eat. I know he knows how to cut shrubs. And I pay the gardener, let's say $100 every time he comes. So that's twice a month, $200 a month. But I'm in a pickle, my son's home, and I say, hey, can you do me this favor? Will you go mow this lawn for me? I will pay you. And my son says, fine, but I want $200 every time I go. I say, okay, I need it done. Go ahead and do it. And I pay him, and he does the job, and we're all fine. We have a huge problem there, because one, that was my son. Two, I allowed a higher rate than I would normally pay the regular gentleman. I have, let's say, I have favored my family using somebody else's funds. You cannot do that. Another example would be, I had a case where the conservator, there was a conservatee that was kind of a friend. His wife was the real estate agent that, this was in a probate though, I'm sorry. So that wife was a real estate agent to sell the house, and she ended up selling it. So she got a commission from the sale, and he was one of the beneficiaries. So I had to report in that case that, yes, the wife of the administrator is the one, the real estate agent who sold the house. But then I also had to show she charged the same fee as any other real estate agent would. And there's nothing wrong in that case, nothing at all. Yes, if your wife's the real estate agent, you wouldn't have somebody else sell it. That'd be wild. You're allowed to do it as long as you just disclose it. And your wife can't say, well, I want to charge instead of 5%, 5.5% or 6% or blah, blah, blah. No, it has to be the same fee that you would pay anybody else, regardless of the relationship. So now we're getting down to where this conservator asks for compensation. It's up to you whether you ask for compensation or not, but it has to be reasonable compensation. And this is the only time you can get compensation to yourself. You cannot pay yourself any other time, regardless of what you do, what you paid out, how much time you've spent. You cannot pay yourself until the judge approves it. And if you do, likely you'll be removed as the conservator when you turn in your accounting. It shows on your accounting, there's no, you can't hide it. So better just don't do it. Now, if you think that because maybe you've put your job to take care of this person and you think that your compensation, you want to be compensated monthly, then fine. On this petition, it is the perfect place. I've got a tickle in my throat and I can't drink. It is the perfect place for you to ask now for a monthly salary fee and let it be approved first, and then you can start doing it, but don't do it up front. But I'm going to go through compensation as if you weren't paid and you wish to be paid. So my example shows that the conservator spent over 150 hours. Here, let me also tell you, I had one where this person says, well, hold on. I give them 24 hours, 7 day a week care because they live in my house, let's say. And I said, really? You're standing there watching them while they're sleeping? Like, or what happens when you need to sleep? Like, that's not even reasonable to ask for 24 hours, 7 days a week. Yes, you may be there, but you're living there and you're living rent free, or, maybe they're living there with you. I mean, it's already your home. So you're really not caring for them 24/7 because you're still doing laundry. You're still doing dishes. You're cooking for yourself anyway. So the extra little meal you cook for them is, you shouldn't be paid for it. Again, you're doing laundry already. You're so really you're not caring for them 24/7, right? You're not. Typically you only see times where, like, okay, you take them to a doctor's appointment. That's not part of your daily lifestyle. So record on this date we spent an hour and a half or 2 hours going to a doctor's appointment, then we went to pick up prescriptions, then we went to Walmart and got incontinence or things like that. Okay, take that time, but again, the courts are not going to allow 24 hours 7 days a week, because they know you're really not caring for the person 24 hours 7 days a week. Anyway, okay, so in this case, the conservator states, I visited the care facility. So see, they were in a care facility where they live. I was there once a week. I made sure she was receiving proper care. That is your responsibility. And that all her personal needs were met. That means her hair is combed, her teeth is brushed, she smells good, her skin is lotioned and nicely to the best. I mean, I'm not talking if there's a medical reason why, maybe she has bruises or she bruises easy and stuff like that. You're doing your best to make sure she's still like you. If you lotion your arms, then, and it's, not allergic or something, lotion their arms, just let them continue to live their life as beautiful as it should be, as I say. Okay, so you state he's the mother, that he's marshaled the assets, he's paid all her bills, he's managed the estate as frugally as possible. The conservatee has arranged So the person arranged for the sale of the automobile because she can no longer drive. He's also, so that means he met with people who wanted to test drive. And so he met with people who wanted to test drive, and he negotiated prices, and he did all this for the sale of the car. Then we're talking the vacation home. So on the vacation home, he met with realtors, he rented it out for some months, and he's just describing what he did during the account period on the vacation home. So basically, for his 150 hours, he's requesting $500. Now, I will tell you that's pretty low, but that's his mother. He knows he's going to be the one to inherit any of her assets at her passing. He's really not worried about the income at this point. That's totally up to you. I'm not saying you should do that, but there is also, depending on what county you're in, depending what you're doing, there is also local court rules from the court that will provide you the hourly rate that you can charge as a non-professional fiduciary. I think right now, or the last time I looked it up, it was $75 per hour. But I would tell you that before you go and charge that, you should look up the local court rules for the court and find out what county, and then look up their local court rules to see what amount you can reasonably charge. Now, you might say, oh, that's a little bit high, she doesn't have much money, blah, blah, blah. Well, then you can adjust your fee based on, what you feel is reasonable and you'll be happy with. Okay, now we're going down to if there was an attorney and you paid an attorney, you must ask for compensation. And say that you did hire an attorney. What the attorney has to do a declaration. They know this, they do this often. They turn in a declaration which shows the date they performed the service, how much time they spent on the service. It will say what their hourly rate is. It will say what was the benefit to the conservatee. It will state a bunch of things, but attorneys know and will do that. Next page, you must state on here if veterans benefits. So in our case, the conservatee did not receive any veterans benefits. The next one is state hospital. You must state all this also. In this case, our conservatee is not a patient in the state hospital. So we have that. On here, a lot of times they state the conservatee's address, or in our example, I myself don't state this. I may state they reside at the Best Care Convalescent Home or whatever. I don't give addresses and all that. It really, people who get a copy of this notice, because you have the notice, everybody will already likely know where the conservatee is. So that's up to you. Account statements, the account statements must be submitted to the court. They must be original bank statements. They cannot be something you printed off the internet. Not allowed. If you, but I have so many people who come to me and say, but Tamara, it was online banking, so they don't send me bank statements. Well, then guess what? You're going to have to go down to the bank, ask the bank to print that whole year worth of statements. They stamp the back of those statements, authenticating that they were printed at the bank, and then you can turn them in to the courts, and that's how you would get your bank statements turned in. Again, you're not allowed to print them off the internet because it's comes out as a PDF, and a PDF can be manipulated or altered, adjusted, anything like that. You also do not turn in the bank statements with this petition in your accounting. There is a separate document, not sure if Rex went over that, but there's a separate document cover page that's considered, you would write confidential on it. And that tells the court that it is not put on the court's website for the public to be able to get copies of those bank statements. So again, you will see indicate that you are turning in bank statements, and there'll be more information here. Capital changes, if there weren't any capital changes, you would not indicate them. If there were, then you would indicate them. That would be, say, for instance, you had stock in Apple and you had 100,000 shares of stock in Apple, and God forbid Apple files for bankruptcy and closes its business. Well, guess what? You've lost a whole lot of money in the stock market off that stock, because your stock is now no longer worth anything. And then in that case, you would indicate something of that nature happening. So statement of estate liabilities. In this case, our conservatee still had a deed of trust or a note due on a mortgage on a property, so it was indicated here. I don't know if I go into this much detail. Balance due on the notes, sometimes you don't know that, but some on the bank statements usually they'll say that. But he states it calls for monthly payments plus interest. What is the interest rate? If you can find out, put that in. Request for special notice is the next thing you must indicate. So let me tell you what this means. Most of the time you will see that there is no request for special notice on file. And the reason being for that is nobody is really interested in the conservatorship that you're handling. And what would be, or how would you know, or why would you know if somebody files a request for special notice? So anybody who is interested in this case, whether they could be any, I could be interested in this case. I would take $40 down to the courthouse, file a form and say, I want to file this request for special notice. What would that mean? Every time you file a document in this case, you must serve me a copy of that document. And if you don't, you could get in a little bit of trouble. So you must indicate on here if there is a request for special notice. I don't know why my mask is going nuts right now, but if anybody has filed a request for special notice, and if they have, you must indicate who they are and their address, and that you're providing them notice. Okay, lastly, what do you want the court to do? So lastly, you're going to say, I, as the conservator, will pray that the court does this, that this account is approved and settled, that all of the acts and what I've done during the period are approved, that the sale of the automobile, because you put it in the petition, be approved, that the sale of the furniture be approved, and that upon settlement or approval by this court, I'm allowed to pay myself the compensation for my services of the amount I requested above. And in my sample, I had an attorney, so I can pay that attorney. Right? Again, if you're not paying an attorney, you wouldn't have that in here. That would not be in here. And then you always state any other relief that the court deems proper. So whatever else the judge wants to do, you're fine with it. I always laugh at that. Like, do you have a choice? No. Then you will date it, and you will indicate your name and sign it as the conservator. Now, when I prepare mine, and I do these often, but I prepare them for attorneys, this is not how they look. The attorney would sign first, David would sign a verification, but, you do them, you know, this is just a sample, you wouldn't have an attorney. And the next page is a verification. Now, there's so many times I also get clients who will contact me and they'll say, can you help me with examiner notes? I say, sure, send them over to me. They send over the examiner notes. And the first item states missing need verified deck, DEC, and that's all it says in there. Like, I can't for the life of me figure out what that means. Instantly, very easy for me. It means this verification right here. It means you didn't include it with the petition. The verification states that you, the conservator of the person that is named above, have turned in an account with schedules and supporting documents, and you declare under penalty of perjury under the state of California that it is true and correct, meaning if you sign this and later on it is determined you lied, fabricated, or did anything unlawful, you can be, legal action can be taken against you. You're verifying here that everything you're doing is true and correct, and you're not doing anything unlawful or wrong. And so that's what a verified deck is. So you will turn that in. Oh, here's the cover page. So in the documents, there's a sample of how you would turn in bank statements and for your account period. And really, it would only say original bank statements. I actually put on mine confidential original bank statements, so I'm clear a second time that everything is confidential. And that's what I have given clients to use to turn in. And again, that is it. Now, prior in some countings, depending on where you are, I think typically up north, you also have to prepare an order. We don't have a sample of the order in here, but basically the order kind of repeats most of this, and at the bottom, instead of you're praying, it is ordered, and then you kind of repeat that the account is settled, that the acts of the conservator are approved, that the sale of the conservator's automobile is approved, that the sale of the furniture is approved, that upon settle that Tamara Brown can pay herself $500 as compensation for services rendered during this period of account. That Jared Roberts Esquire, that the conservator is authorized to pay Jared Esquire the sum of $3,500 as a reasonable compensation. So your order is going to kind of mirror what your petition is. You're going to turn this into the court. You are going to get a court date. Again, the court will stamp it received, get a court date. You will do a notice of hearing and give everybody a copy of your accounting, and the petition will, the accounting will be an exhibit of this petition. So it will be included, you will serve everybody, and then you wait till your court date about 2 weeks before, maybe 10 days. You get tentative rulings or examiner notes. It could be called either or. And basically you have only a short time period to correct anything that the examiner states is wrong, because it has to be done before the next hearing date. Well, let me back up. So if you get examiner notes and you want to try and clear them before the hearing, so your hearing will still take place, then you have a very short time period. If you know you cannot answer and get whatever is needed, or you cannot do whatever is needed, then you go to the hearing and get a continuance, and then you have a little bit more time to correct those items and get them done before your hearing. And then you don't, then you just wait for the hearing date. Again, you'll reissue another notice of hearing to everybody on the new hearing date, and you'll go forward. So that is the end of the class. That's all I have. Do you have any questions that you wish, oh, why my nose is so itchy, but that you wish to ask before we end? There's 5 minutes left. So go ahead, hon, if you have questions.
So could you please show me the confidential form? You said that there's some writing you showed before. It's very quick. I have a lot of.
I'm sorry, honey. It's all part of your documents that you were sent a link to, but yes, I would be happy to show it to you.
Oh, I have that document to show. Oh, that's a statement. This first accounting report conservator. Is this original bank statement for? Oh, I needed to put this document that says this is the original bank statement.
Right, and then you'll put, then this is the only way you can file the bank statements with the court. You'll put the bank statements in their printed form behind this page, and then the court will stamp this filed. You must have a copy with you, but the court will stamp that filed, and that is your receipt that you filed the original bank statements.
Okay, so if I filed the original bank statement, I would have no more original, and another difficulty is because my conservatorship was removed. Conservator the bank statement I would not be able to access again once I filed. Because
you're supposed to, honey. You're supposed to keep copies. It's nobody else's responsibility.
Yeah, I kept copy. If I filed the original, I would not have original. If I
you don't need the only person who needs an original is the court. So you keep your copies.
Yeah,
you keep your copies, and you don't turn your originals in till after you're done with your accounting anyway, and you turn in the petition. So your copies are perfectly good for any other year, any other time, any other purpose. It's just the court requires the originals, and you're not allowed to keep them. You must turn them in, but you don't need them. There's no purpose that you need those bank statements.
Oh, okay. So if I don't have it, then I have to obtain from the bank. Because I have been filing a couple of accounting multiple times. The bank statement is already gone because every time I have to attach the banker's statement when I file the accounting. So I have been amended a couple of times. Maybe I needed to find some way to get the original bank statement.
Well, every single month, now that you have to have an original bank statement. So every single month, you need to be taking a little trip to the bank and getting you an original bank statement that you'll need for the court.
Yeah, but I mean, I just turned it in earlier, then I'm refining the accounting, resubmitting the amended accounting. So the original already gone at the first time I turned it in. But anyhow,
you don't turn in originals a second time. Once you've turned them in already, you're not responsible for a second time.
Oh, so right now, if I do it again, I just make a copy because I already turned it in to the.
You just don't worry about turning in bank statements. You submit your accounting, and you already have receipts that you've turned in your original bank statements.
Oh, okay. So, but I did not do the way as you showed. Have to have a special those filing.
Okay, however you did it, if the court approved and accepted those bank statements, you don't have to worry about it.
Ah, okay, okay. As long as they did not ask me to for the original bank statement again, so I don't need to do it.
No,
So-
even if they did ask for your original bank statements again, all you would do is you would then do a declaration that says, I already filed them, and show your copy or show something
Yeah.
that shows you've already turned them in, and then that's it. You
Okay.
don't need to turn them in a second
Okay.
time.
And the last question is, sell the car for gain, not for lose. Do I need to get approved? Because I saw that.
No, to sell anything of a conservative's property, you have to do you have to get approval from the court. But I think you should read the conservator's handbook. It's a huge, like 300-page document. It's on the website or on the internet. You just type in conservator's handbook, and it will tell you what items you can or cannot sell on your own without asking the court first.
Oh, okay. So
Now, you don't have to print that book. Just look
okay.
up on the internet, look up and see, okay, type in the search menu, want to sell the car. Type in the search menu, want to buy a car. Type in the search menu, whatever, and only read whatever you need to read for your answer, and then just know that it's on the internet and you can always research anytime.
So what's the reasonable rate for the conservator to charge for conservatee? In some cases, since the conservatee has a severe injury, is cognitively disabled, and they needs interpreter all the time. Because they had the caregiver provided, but the caregiver cannot speak his language, so I have to be there all the time to.
Well, then you would charge, honey, then you would charge for that. But I can't tell you what a reasonable amount. What's reasonable to me might not be reasonable to you. What you think is reasonable, I'll go, whoa, that's a lot of money,
Okay, that's right.
Right? I don't know what is reasonable to you. I could say an hour's worth of work at $50 an hour is reasonable. You go, oh no, I'm too skilled for that. I want 70, I don't know. What is reasonable to you is what you ask for, and the judge determines, okay, it's reasonable, or no, I'm not giving you that much. You're getting a much smaller amount.
Okay, as long if the accounting not get approved, so what's going to happen if I keep finding that never get approved? So
you're going to have to find somebody and hire somebody to do it for you who knows what they're doing and how to do it, and it will get approved sooner or later. The courts will force you to do that.
Yeah, so
you don't have to do the accounting yourself. You can hire somebody who does court accounting to do it for you. So if you try and you're not successful, well, then you're wasting a whole lot of time and a whole lot of effort when all you have to do is hire somebody. Why not? It's not your money. You're not paying me. It's the conservative who's paying, whoever for the accounting.
So I have hired somebody that never get it done. So do you know anybody is good at those?
Well, Rex's office does accountings. I separately do accountings. You can go to the Contra Costa Law Library. They could probably refer you or give you. In fact, I think they have a referral list of professional fiduciaries. Some might, you can call them and ask them to do for you. You might, I don't know. I think if you ask the probate examiners at the courthouse, probate examiners, they can give you a referral page. I know both Rex and I are on that. You could, search the internet for someone who does conservatorship court accounting. And there's many ways you can ask somebody to help you.
So if I ask you to do that, do you think how much it would cost for those?
Now that's the problem. No one can ever tell you, whether it's me, whether it's Rex, whether it's until we actually see bank statements and can see the details of work and can see how many entries and how much time. And I myself, and I can't speak for Rex, but I myself charge hourly. So it depends. How long is it going to take me to do it? I don't want to say, for instance, I'll do a project for 2,500. Let's just say I'll do a project for 2,500, and I spend 3 weeks every single day, 8 hours a day, trying to get the accounting done. I'm not going to do that type of accounting for $2,500. I'm not. Because that wouldn't even cover my time. And I would lose out on that. So I myself, I again can't speak for Rex. You can ask Rex, but I charge an hourly rate, and I would say most other people, like fiduciaries and other people who do accountings, also charge an hourly rate. And so you just have to figure out what is the best for you, and what you want to pay, who you feel is confident, what you want done, things of that nature. Again, this is not you paying, this is the conservator paying, and the conservator has to have this accounting. So it's their expense, it's not yours. And so you're not required to know how to do an accounting or a petition or anything. Your job is just to get it done. So if hiring somebody is what you need to do, then honey, you do what you need to do. Now, we used to have a list of people, so you can contact Rex's office. Well, you can contact, since you came from the law library, there's a phone number here for the law library, and you can call and ask them for phone number. They might have a list of people. You can ask for Rex's phone number or my phone number. Or
maybe I just get your phone number or Max phone number, so maybe I just might be simple. I have all the data entered already in the spreadsheet.
Well, that wouldn't matter, honey. It wouldn't matter to me. I don't look at anybody else's. You're responsible for your accounting. If you hired me or somebody like me, I do my own because I'm responsible for it. And I don't want to try and figure out what you did wrong or right or whatever. I don't have time for that. I am going in with, I look at bank statements, I look at inventory and appraisal, and I do the accounting. It doesn't matter to me what your spreadsheet is. And in fact, you cannot even hire me to review your work. You can hire Rex to review your work, but you can't hire me to review your work. I cannot do that.
So Rick, he can do that to review.
Rex is an attorney, so he can review somebody's work and give an opinion on it or state whether it's proper or not. But you would really have to talk to him, hun. I'm not an attorney. I cannot give you legal advice. I cannot review your work and say what's wrong or whatever. That's just not something I do. I would take your bank statements, take your inventory and appraisal, and I would complete the accounting on my own.
Oh, so that how many hours? What's the hourly rate you would charge?
My hourly rate is $95 an hour.
Oh, 95 per hour.
I think Rex's is $125 an hour.
So what's the contact information? Maybe I can, and let you guys just handle it,
Sure. So if you want Rex to review and do
Yeah.
yours, his phone number
Okay.
is, let me find it, honey. I'm trying to log on to 925-934.
934
6320.
6320. So your number is
My phone number is different than his.
yeah.
My name is Tamara and my phone number, and you will see my name right
Tamara.
right here.
Okay.
And my phone number is 916
916
802
802
0044.
0044. Okay.
And like I said, you are free to contact the law library. You see where I have highlighted their phone number, and
Yeah.
you can get a list of people from them who would be able to do it for you also.
Okay. So
If you want to shop around and get prices.
So I don't want to shopping around. I just get it done. Maybe I will contact you, or maybe Remax, Rex to, let him review first. If he said, I needed to redo that, I let you just redo it. Because
That'll cost quite a few hours.
yeah, so
that's up to you, honey. I think his fee is 125 or 150 an hour.
oh, okay. Yeah, but anyhow, that might be,
But it would take 4 or 5 hours to review somebody else's work.
Yeah, that's fun. Just let him review, then say what if it's fixable or not fixable. If not fixable, if it's harder to fix since it started, maybe I let you start redo everything. Okay. From the beginning, because I try to save some work we have done. If not, it's not worth to save. It just restart.
Okay, sure.
To make sure it's get approved, because
that's your whole goal.
Yeah,
so,
yeah.
It's 10 minutes after I gotta go to lunch. We're over. So thank you very much. You can always retake the class. Our next class is April 18th after the tax season. You're free to take it as many times as you want. Otherwise, let us know, and if you need anything, and either him or I can help.
Yeah, if you redo it, you would do all the pleading, everything together, right? File.
It depends. If you ask me to do the petition also and the order, then yes, I do that. I don't know that Rex does that. I can't tell you.
Okay. Okay, thank you very much.
You're welcome, hon. Take care and good luck, okay?
Yeah.
Thank you.
Okay, thank you.
Okay, bye-bye.
Bye. How to get out?
I don't know how to get out either.
Me too, either. Maybe not sure. Oh, okay, here's the leave button.